Hello, for Home Quiz 2 by IQMAL Daniel and Roin Shahzani, we are going to discuss about the delays, liquidated and ascertained damages and extensions of time. Firstly, in the video, the guy explained about extension of time. The importance of it is because if the employer causes delay like changing the work and there's no way to adjust the deadline, the contractor is no longer bound to finish by the original date. Instead, they just have to finish in a reasonable amount of time. The purpose of EOT is EOT clause is to prevent time from becoming at large and to preserve the liquidated damages provision. By extending time, the completion date can be moved back, allowing the employer to claim liquidated damages from the extended completion date if the project is still delayed. Secondly is about liquidated ascertained damages. LAD are pre-agreed financial compensation for delay that can be calculated without proving loss. Penalties must be reasonable to the actual breach of contract. LAD can be enforced, unlike penalties, which are regarded unenforceable under public policy standards. An example illustrates that even if tenants don't move in due to a recession, resulting in no actual loss of income, the employer can still claim pre-agreed LAD for the delay. The case of Cavendish Square Holdings versus Makdeshi, also known as the Bucking Eye case, emphasizes that a penalty serves a deterrent aiming to frighten the contractor into timely completion. The video also explained about the impact of termination on LAD and contractor delay losses. First, liquidated damages only apply if the contractor finishes the work. If the contract ends because the contractor goes insolvent, LAD don't apply unless some parts of the work were already completed within set deadlines. Second, if the contract ends due to the contractor's insolvency and there is no sectional completion, the employer can only claim general damages for delay, not LAD. Third, the key case for the contractor delay claims in Glen Lyon versus Guinness, which is based on the contract completion date. If a contractor plans to finish early and gets delayed past their planned date, they can't claim for the debt delay. That's because the employer only promised to let them finish by the contract deadline, not any earlier. The video also explains about applying for extension of time under the JCT contracts. A contractor usually doesn't lose the right to an extension of time just because they didn't apply for one. In Ladd versus London Borough of Merton, the court showed that JCT contract often allowed the contract administrator to review delays within 12 weeks after practical completion. Most contracts say the administrator should consider delays even if the contractor didn't apply, so not applying isn't always a deal breaker. However, delaying notice can hurt the contractor case it might make it harder for the architect to assess or reduce the delay. When applying for an EOT, the contractor must explain what caused the delay, such as variation or actions of employer.
Beside of that, based on the YouTube video talking about applying for extension of time under JCT contracts, a contractor doesn't always have to apply for an extension of time to get one. In Leck versus London Borough of Merton, the court noted that JCT contract often allow the contract administrator to review delays up to 12 weeks after the work is finished. Most contracts say the administrator should assess delays even if the contractor has not applied, so missing an application doesn't not automatically block the claim. However, giving the late notice can hurt the contractor as it makes it harder for the architect to assess or manage the delay. When applying for an EOT, the contractor must explain what caused the delay, like changes to the work or action by the employer. The case Water Lily versus Mackey support fair treatment of contractor in delay and cost claim. Impact of termination on liquidated damages and contractor delay losses. Consequent delay happens when two or more delays overlap in time. Court assess delays based on evidence and balance of probabilities. Under JCT contract, full EOT can be granted for consequent delays but not compensation. Scottish law split delays between parties. JCT allows clauses blocking EOT for consequent delays, not Midland versus Sided. Walter Lilly versus Mackey, snagging is normal and not a delay unless excessive. Contractors do not lose claim for loss and expensive if some details are missing. Reasonable info or access to record is enough. Claim should not be judged too strictly when the delay is the employer's fault. Global claims are allowed if the contractor shows losses were not due to other causes, like underpricing. If part of a global claim fails, only that part is removed, not the whole claim. For validity of clauses restricting extension for consequent delay, the North Midland Building versus Sidney Homer's case decided that an EOT clause is valid even if it ignores contractor delays when they happen at the same time as employer delays. Second, the court ruled that the employer can still charge liquidated damages even if they cause part of the delay as long as the risk allocation is reasonable and agreed upon by both parties.
The first case is about Daya CMT Sdn Bhd versus Silk Town Construction Sdn Bhd. The parties involved is Daya CMT as plaintiff and the main contractor, and the defendant is Silk Town Construction as an employer. The contract nature. The dispute arose from a construction contract for the development of a mixed-use project. The issue is Daya claimed an extension of time and loss and expense due to late issuance of instruction variations and delays not attributable to the contractor. The developer Yuktang denied these claims. The relevant clauses cited. The contract was based on PAM 2006 form private edition. EOT and delay claims were central to the case. So the court judgment and decision is the court found that Daya was entitled to a partial EOT based on documentary evidence showing employer caused delays, for example, late issuance of instruction. However, Daya failed to fully comply with the notice requirements and procedural steps under the PAM contract, for example, giving prompt notice of delay events. The court held that only partial EOT and loss and expense were allowable proportionate to the periods with clear supporting evidence. So the decision is the court partially allowed the claim. Neither party won fully, but Daya as a plaintiff succeed partially in claiming an EOT and a portion of loss and expense. The first issue is late issuance of architect instruction, and the clause related is PWD 2010 clause 43.1 E and F, delay in issuing instruction or drawings essential to carry out the works. For PAM 2018, clause 23.8 E and F, failure by the architect to issue instruction. For the second issue, late handover of site possession or access, which is certain section of the site were not handed over on time. The clause related is PAM 2018, Clause 23G, failure of the employer to give possession of the site or part of the site. CIDB 2023, Clause 23.1I, failure of the employer to give possession of the site or part of the site. And Clause 34.1K, failure by the architect to issue instruction. For case number 2, it is about Anjung Hijau Sdn Bhd versus Associated Builders and Contractors in 2024. The plaintiff is KL Eco City as the developer and the defendant is Taksin Engineering Construction as the contractor. The fact is, the plaintiff is the developer of the project. The first defendant was the main contractor appointed by the plaintiff for the construction of the project, and the second defendant was the architect and contract administrator of the project. The third defendant is the professional architect. The issue is the delay was due to Z&A issuing a second engineering instruction to defendant 1. Engineering instruction number 2, instructing defendant 1 to lower and reconstruct the main drainage system along the project boundary within Ungku Omar Polytechnic. The plaintiff contended that all three EOTs were null and void and should be set aside, and because the EOTs were null and void, the plaintiff did not owe defendant 1 the balance of payment for the work done by defendant 1 for the project. The plaintiff also sought damage in the sum of 3 million ringgit, being LAD. Defendant 1 counterclaimed from the plaintiff the sum of 3 million ringgit being the balance of payment due and owing from the plaintiff to defendant 1 for the work done for the project. Court decision is under clause 23.10 of the PAM 2006, Defendant 2 may review and fix a later completion date than it had previously fixed within 12 weeks of the CPC. Hence, the fact that Defendant 2 had granted EOT3 and fixed a later completion date that earlier fixed under EOT1 more than 12 weeks after the CPC did not mean that EOT3 granted by Defendant 2 was in non-compliance of Clause 23.10 of the PAM 2006. The plaintiff had failed to prove that the grant of the EOT1 and EOT3 were wrong. Accordingly, the plaintiff was not entitled to any loss and any damages for LAD resulting from the issuance of EOT1 and EOT3. The plaintiff was obligated to pay Defendant 1 for the works done by Defendant 1 for the construction of the project. The clause that are related to this case is PAM 2018, Clause 23.10, Architect's Review of Extension of Time After Practical Completion. Next is on PWD 2010, Clause 43.1F, and in CIDB 2023, Clause 26.4, EOT during delay period after CPC.